you awake? Yes. So I'm Kayma Harris. I work for the JCMH. I'm going to first just introduce you to the JCMH. So we are a commission under the two highest courts of Texas. So my bosses are the Supreme Court of Texas and the Court of Criminal Appeals. So that's exciting on staff meeting days. But it really is a good organization. The two high courts have never come together to create anything as a unit. And this was the first time they did that. They had a hearing, as you can see in this photo, and they heard testimony about what's happening in the courts across Texas, dealing with mental health, substance use disorder, and IDD. And then from that, they created this commission. So we are charged with engaging and empowering these court systems to really improve the lives of people with mental illness, IDD, and substance use disorder. And how we do that is we have a commission of people. So about 50 experts in the state get together 4 times a year to have a meeting. But if you've ever had a meeting where great ideas come out and then nothing happens afterwards, that's what we are here to prevent. So as a staff attorney, our job is to write down everything brilliant that was said and then try to execute it, try to go out into the community and make these ideas come to life. So one of the ways we document those ideas is through our bench book, which I've brought some here today, but also doing different teachings. We have a summit. We just really try to interact with the Texas community. Everything we have is free. So if you see anything up here, or I talk about a book, it is free and you can have it. It will be online, but also I can ship these to you for free. So what is mine is yours. Please, however we can help you, let us help you. So mental health law is really vast and complex and niche. And something about me is I really like charts. I make a lot of charts. Any chart you see in here I probably made. I like to get really into the details. And this next chart might be overwhelming at first, but what it is like, it holds all of the mental health laws. We tried to put them in one place. My boss called them core competencies at one point, but it feels a lot more than that. So this is across the sequential intercept model that you just heard about in the previous presentation, and kind of how these different laws that we as attorneys have to understand and how they work and how they fit together. So today, you guys are just in this little box right here. And there's so much more that interacts, and you guys know all this already, but hopefully we'll only focus on this box, but there's so much more. So anything we can do to help you on all of this, not just competency, we are here for you. And we're all learning this, and like they said, if you've been to one court, you've been to one court. Everything happens differently in different counties. As we go in and explore different counties, we're finding that that is very true. But because we get to go around to different counties, we get to pick up good ideas and then bring them to other people across the state. So I find that super fun. I will be taking back forever bonds into our programming for later. So that was new for me today. So today, before we get into all of this, we're actually gonna play a game. No, you don't have to get up. We're gonna play Never Have I Ever, okay? So, do you guys know what that is? So we all played it in like high school probably. It's about competency, don't worry. And you hold up your 10 fingers, and then for everything that you have done, you put down a finger. So, for example, I've never gone to law school. Well, I've gone to law school, so I'd put down a finger, right? Okay, so let's start with our 10. I have never had a client who was found incompetent. If you do it, there is a prize at the end. I've never disagreed with a competency report. I've never helped a client get treatment. I've never confused drug use and competency. I have never had a client on my caseload die. I have never had a client die waiting for competency restoration services. I have never felt helpless in helping my client. I've never felt regret about how I've handled a past case. I have never been thanked by a client who was sincere. I have never seen the impact that I've had on a client's life. I have never gone to a competency trial in front of a judge. I've never gone to a competency trial in front of a jury. I've never used a forever bond. Okay, where are we at with our, I'm at 2, you're at 0? Any other zeros? The forever bond that Elise talked about. If you're 0, will you raise your hand? Wow, that's a lot of zeros. 1, 2. Okay. Well, I have books up here. I have 9 books today. So will you raise your hand one more time? 1, 2, 3, 4, 5, 6, 7. Okay, good. So the 2 books that I have for you are the bench book that Elise talked about. And then the other book we have is a code book. And that is all the mental health codes from all the different codes put into one book that you can keep with you. So mine is all tabbed up. These are both available electronically. And spoiler alert, if you give me your address, I'll mail them to you. But 7 of you already have one of these books today. Excuse me, I have to cough. Okay, so today I'm going to start about the policies behind the law, kind of a behind the curtain look at how we got here, and then the lessons that we've learned about competency restoration services. And this is kind of like things I wish I knew 10 years ago, right? And then we'll get into some of those complex 46B situations that Elise touched on. And so you may hear some repeat information there, but mine will be more detailed and more procedural, because that's just how my brain works. So I hope between Elise and I, there are ways of teaching it can help everyone. So how many of you went to Texas Tech Law? Okay, how many of you had Professor Shannon, Brian Shannon? Yeah, he's great. He's on our commission, and he helps with writing a lot of these laws. So he helped with 46B competency restoration law. In 2003, they were finding that no one was going to competency restoration services. It wasn't being brought up. People weren't being declared incompetent. They were just going through the system, and that was a huge problem. And so they decided to change the law. And never in a million years did they think there would ever be a wait list. And here's where we are now. So it used to be a bona fide doubt had to be raised before you could get over that threshold of competency. And it got changed to this suggestion, this mere suggestion, just a mere suggestion, and you're in, right? And you start down this process. But they did this because nobody was using it. So they wanted to safeguard people who are not competent from going through and taking plea deals and getting pushed through the system. And so it kind of went from one side to the other, and I don't know where the middle will be, but that's kind of how we got here. And when you look at the laws, I always think of this like the incompetency train. Like if I just suggest incompetency, then we're gonna get on this train, and the court is required to conduct this informal inquiry. If there's some credible evidence at all, we must stop the case. We must order a competency examination. We must hold a competency trial. And you heard about the Blunson trial, which is a smaller version, but it is still an effort to put that on the record. It is still a must in our statutes. So this law is set up that if you raise it, you're on that train, which is why Tim Bray and Yolanda's presentation is so important. We don't want to get on the train at all. I don't want to be there at all. But if you are, we have to handle things in different ways to try to either divert off that path or figure out a way to actually help our client. So the lessons learned behind these competency restoration classes. I remember sitting in a CLE, it was a brown bag lunch CLE in Williamson County, and listening to a mental health CLE. And the person in front of me said, competency restoration is not mental health treatment. And my jaw was on the floor, right? So I was shocked. I'm like, no, I send them for treatment. I send them to get help. I help them. But treatment and competency restoration are not the same. And I know that Tim talked about this a little bit, this legal definition, and really looking at what the theories are behind why we're doing these. And I found this quote in a article that I was reading lately, and it really stuck with me, and it mirrors exactly what Tim said. So hospitalization for the purpose of competency restoration should not be confused with therapeutic inpatient treatment, as they serve distinct goals. Inpatient treatment is a vital part of the continuum of psychiatric care and is used to help achieve long-term wellness and recovery from symptoms of mental illness. Along with medication, this involves working with the patient to foster continued engagement with treatment after discharge. Because competency restoration serves the more limited short-term goal of preparing the defendant to face trial, restoration, quote-unquote, treatment is usually limited to medication and basic education on the criminal court process. The purpose of hospitalization is to serve the interests of the criminal legal system, not the client. And I know you know this already, but every time I read that quote, it hits me like, I am helping the state. I'm helping the state prosecute my client by sending them to competency restoration services. So if I want to help my client, there has to be something else. We have to do something else. Here's the goal of competency restoration that I just talked about. And then here are some of the symptoms that was talked about earlier, what you might see in your client. So this confusion about these simple legal concepts, the unrealistic appraisal of outcomes can come from anywhere, not just that symptom alone, but these other issues may be raised. What about when you get into the class? What does the class look like? So the class says things like, the judge is the person who's in charge of the trial. He sits in front of the courtroom and wears a black robe, right? That's the curriculum that your client is learning in competency restoration services. I mean, I swore they were getting comprehensive mental health treatment. I cannot believe what is actually happening is that they're learning who the judge is. Like, that blew my mind. As I remember being a baby lawyer, just sitting there and going like, my world has been shaken. And we go into a lot of counties who still believe competency restoration is comprehensive mental health treatment. And so kind of breaking down that understanding for our peers is very important. A lot of prosecutors don't understand that either. And they can't, I have found that they can't understand why we can't just send them, like, why is that not the solution? And that is how we get a really backed up system and we get misdemeanors on the wait list. So, on to these the complex 46B situations. I've called them something different than what Elise called them, but we have the situation where someone is incompetent and unlikely to restore, incompetent and unrestorable. And by that I mean they have gone to competency restoration services and cannot be restored in the time period. Then the other tricky situations are about misdemeanors and state jail felonies. So they've timed out or will likely time out before anything can be done. So these are those kind of definitions as I see them, as I'm discussing them. And looking at the report is important, both for the judge and for us, seeing what that time period needed to restore the defendant to competency. Because they might say, oh yeah, they're restorable to competency. It'll take about 5 years, right? So that is, in actuality, someone who's unlikely to restore. So looking at what exactly they're saying and how they meant it, and like Elise said, give them a call. If they don't give you that information, they need to. You're entitled to it. So give the examiner a call and figure out what's going on. So these prospective treatment options, if appropriate for the defendant. I like those things in reports, because that's something I can take to the judge and say, let's make a plan. Let's do this instead of competency restoration. Or take to the prosecutor and try to get them to think creatively, like Elise was talking about. So here are those time frames. You guys seem to know them really well during Jeopardy and shouting out to different, during Elise's. But here's what they are. I think better in charts. So here's a chart versus the statutory text. So someone is unlikely to restore. So they're incompetent. You have them in front of you, and nothing's going to happen. So what the statute directs you to do is to look to the Health and Safety Code. And then there's a giant groan because nobody likes to look at the Health and Safety Code. It jumps around. The 46B law says that if something is different than the Health and Safety Code, that the 46B applies. And you're like, well, do they conflict here or do they conflict there? And I don't like the Health and Safety Code. But here's what we learned from it. There are two different ways in 46B to do what's called civil commitment, or now appropriately called court-ordered mental health services. So there's two routes. The charge is pending, so your prosecutor's not dismissing it, and your charge is dismissed. The charge is dismissed is easier, right? Because you can get them out of the criminal court, then they just go about it how they would if somebody came in on an emergency detention or they were in the hospital and the state is wanting to do court-ordered mental health treatment. The charge is pending gets a bit more complicated. Again, with my charts, right? So this is someone who the report says unlikely to be restored in the foreseeable future. Then, if the case is dismissed or not dismissed, what part of the code it sends you to. So it sends you to the 46B, which eventually sends you back to Health and Safety Code. For someone who's unrestorable, you kind of end up in the same place, but with the detour of going through competency restoration first. So this is a chart that HHSC made that I commandeered and, what's the word? Abbreviated, perhaps? So this is, they walk you through, okay, they're committed, they go to that competency restoration in whatever form it might take. If they're restored, the criminal case proceeds. If they're not restored, kind of 3 different things could happen. And either everyone just forgets about it and they dismiss the charge, or they dismiss the charge as civil commitment, or they don't dismiss the charge and you try civil commitment. Here's the other half of that chart. I did make a typo. This should not be grayed out. You're supposed to be able to see it. So we'll just give you the full thing now. So someone's likely to restore. They go and they do that restoration. There is the maximum time that they're allowed to be there. They're either restored or not, and then the state has that choice to make. And then you are back to the Health and Safety Code. Civil commitment. Have any of you done civil commitments? Yeah, I had never touched it as a defense attorney. So there's things that the court has to look at. For the one with charges dismissed, this is going to your probate court. Well, it's your court with probate jurisdiction, excuse me. So your court with probate jurisdiction would get this case. And they would say, or I'm sorry, back up. Your criminal court makes sure that there's that finding of evidence to support mental illness or intellectual disability. This is where we get into that situation about like traumatic brain injury or dementia, but we'll get to that later. So say there is a finding of mental illness, then they transfer it to that civil court, the court with probate jurisdiction, and then that continues kind of as it normally would in the civil realm. According to the statute, the defendant may remain detained in jail or another suitable place during this period of time while they're waiting for that civil commitment to happen. A responsible person could take them in, but just know that, I mean, they could be stuck in jail, and that is not conducive to their mental state, as we talked about in an earlier session. So whatever we can do to get them to a different area while they're waiting for actual help rather than competency restoration. So charge is pending. Is there evidence to support a finding of mental illness or intellectual disability? Then you would move on to this. The criminal court now gets the civil commitment proceedings. So everything the probate court would do, the criminal court is going to keep it still in its jurisdiction. And they have this kind of finding of violence. And this is important for where the defendant might get to go if civilly committed. So that finding of violence will happen. I wrote this on here because how they do the finding of violence is either the finding of a deadly weapon or an offense listed in 17.032. 17.032 is the mental health personal bonds list. It includes a list of violent offenses. This past legislative session, that list was carved out from 1703, which is just your normal personal bond statute. So that personal bond statute says you can't give bonds to this whole group. And we were able to get it carved out. Now those lists are slightly different. So be sure to pay attention to the differences between the lists. One important difference has to do with an assaultive offense that you would typically see if someone maybe got taken to the ER and they assault a doctor or a peace officer while they're in that state of crisis. It is carved out in 1703 too. So that's important for bond conditions, but also for this, just to know that they're different, and there's actually a reason behind it. So we get into the health and safety code. There's 4 different ways to do this, kind of a mix and match. I feel like it's the granimals of civil commitment. You guys know what granimals are? Yeah? Okay. Close that match and you can switch them. Anyway, so there's temporary inpatient or temporary outpatient. Then there's extended inpatient and extended outpatient. The 2 legislative sessions ago, these got cleared up and the code separated out into 4 different sections. And we're gonna look at the inpatient version of this because it's less likely that you'll encounter an outpatient situation if your defendant is in jail on a felony offense, and the state's probably not gonna be like, yeah, let's send him outpatient. So we'll go down the path of the inpatient at this time. Here is the statute. So that proposed patient is a person with mental illness. That's the big one that Elise talked about. That's actually a big deal, although it looks like a shoo-in. And then the A and B is that risk of harm that Elise was talking about. So is someone going to hurt themselves or likely to cause harm to self or others? But then we have this deterioration standard. So this part down here doesn't get talked about a lot, but it comes down to like, are they in a mental place where they can actually care for themselves? Are they not eating or drinking or providing for their personal basic needs to the point where it comes to life and death, right? They're not gonna, they can't care for themselves. So that deterioration standard could be used in certain circumstances. It does say they have to be able to provide food, but indigence doesn't count. So if you're too poor to eat, it doesn't count. It's an odd carve out to me, and I could soapbox that all day. But anyway, there's that deterioration standard. The other thing happening here, if we go from temporary to extended, they add a couple of things. There has to be a finding that the defendant will likely stay there for more than 90 days, or be in that state for more than 90 days, and also that they've received this court-ordered inpatient mental health services for at least 60 days. So what if your client was found unlikely to restore, the state is not going to dismiss it, you proceed under 46B subchapter E with charges still pending, criminal court gets those, you then go into the health and safety code, and because competency restoration services were never attempted, the state must do temporary first. So they can't jump into, okay, we want inpatient mental health, court-ordered mental health services inpatient for a year. Because he never went to services, we don't have that criteria met. So they have to do that 45 days one, the optional increasing of extending it for 45 days, then you've hit your 60 days within the past 12 months, then they can go on and do this extended. Lots of complex processes happening here, but I guess a little tidbit to know. Like if they didn't go to competency restoration, the state's not going to be able to get extended. Let's see where we are. Okay, before we get to timed out, at one point, we all like war stories, right? So I represented a group of brothers, and we all know kind of, in our counties, there's like a group of brothers who, they're kind of notorious for getting in trouble. And so at one point I represented the eldest brother, and that was in evading with a motor vehicle, and he ended up hurting a peace officer, and it was a big old mess. However, he wasn't driving the car. We were able to prove he wasn't driving the car. The case got dismissed. Yay, everyone's happy with me. Then I get his younger brother. He comes in, it's assault, a family member with a knife. This man is not competent. He's definitely not competent. Deteriorating within jail, it was not, it was what you would expect, I guess. So we get the competency eval done, and not competent. They said likely to restore. I'm going to disagree based on other information that I learned. I learned he had a rap sheet, a ridiculous rap sheet. So much so that, the state's they're not backing down. They won't let me do anything. They don't even want to do civil commitment route because he's such a bad guy. But between the last time he was arrested and this time that he was arrested, he was in a car accident. A very bad car accident that killed his other brother, not the oldest one, the third one. And he had traumatic brain injury. So we find this out later on. So we're in this situation. So he's on the wait list, been there over a year, but should he be with traumatic brain injury? Is he really gonna be restorable at all? Anyway, this is kind of coming to a head, and I switched jobs, right? Not on purpose, didn't mean to leave him, but we all have our lives, right? So I moved towns, I moved jobs, and The place I was working attempted to do the civil commitment route. Based on the traumatic brain injury, he doesn't qualify for mental illness under the civil statute. Right, so we're in that pickle predicament, the forever bond situation. The state is not going to do a forever bond because he has this giant list. And maybe your states have this, your prosecutor offices, some of them may not believe that mental illness exists. Anyone have one of those? Yeah, a prosecutor who just is like, oh, man, that's not real. Mental illness doesn't exist. How could you? That's some counties. So there we were. This situation was happening. The fight was coming to a head, but I was no longer involved. Right? I kind of had stepped out, got pregnant, about to have a baby, get a phone call from the magistrate. Magistrate judges were friendly, and he says, hey, you remember that case you had with a guy? So, yeah. Well, he stopped eating and died. I mean, what do you do there? Like, it still profoundly shocks me. But it's one of my cases where it's like, there's that regret of like, what could I and what should I have done differently? And I'm not sure that I know the answer at this point. But these things happen and they're horrible, but you're not in it alone. We've all gone through this. I still don't, as I think back on this case all the time, like what? But really, like you're in that pickle between not competent, not restorable, not civilly committable. And it is a limbo. Other than a forever bond, has anyone figured out a way to deal with that? Yes, sir. The John what? Okay. what are you asking for in that writ? What's your? But if they're Marissa? Yes. Right. Mhm. Right. Mhm. Yeah. So that goes directly, that email address goes directly to Dr. Felix Torres. He's the director of forensic um, something at the state hospitals. And his team is great. That's the team that will come in and do like a reevaluation that Elise was talking about. You talked about the writ and how he was schizophrenic and could go to the state hospital. What about when there is no reason to go, right? Not restorable, not committable. Exactly. No mental illness, no IDD, because like dementia, traumatic brain injury, not competent. That, I think a writ might work, but then like, what are you asking him to do? Yeah. Uh-huh. Yep. You to feel comfortable enough to get there. Yeah. Yeah, so really putting pressure on those entities. Thank you, and I will look for that writ. I appreciate that. Let's move on to slightly lighter topics. Timing out, much more likely to happen on your watch. So Elise talked about um, someone timing out because they're a misdemeanor or a state jail felony. So timing out, what does that actually mean? So there's a law that says there's mandatory dismissal of a case, misdemeanor charge, when the defendant isn't tried before the expiration of that maximum period of restoration. So they have done this inpatient, residential, jail-based, outpatient, some combination thereof, or they're waiting to go there and they don't get there in time. That's when that mandatory dismissal kicks in, and it's important to keep keep that in your chart, I guess, or your file, like when that date does hit. Something to know here, that is that 2 years that Elise talked about, if a defendant is charged with a misdemeanor and only ordered for outpatient competency restoration, then that max period becomes 2 years rather than the statutory maximum punishment. So that is kind of where that flip happens. Little equation here. So this cumulative period is equal to that max sentence allowed by law, which potentially is that two years if it's OCR only, and does not include the enhancements. So this ex parte Reneke, I'm not sure I'm saying it correctly, is that case, and we talked about it, I think, during lunch, that if they're being enhanced, those don't count against that max sentence time. So there is definitive case law on that for your argument to your state on when they hit that max period. But the law goes through what all is included in this cumulative period. So all the time the defendant was held in jail at all, before or after they were ordered for competency restoration services, the time they're waiting for competency restoration services, and this good time credit. So pretty much how you do your time anyway when you're looking at back time. However, if they are released on outpatient, the time that they are released and waiting to get into services, or the time that they do outpatient, that also counts. So make sure you're getting those days where they're in the community included in your cumulative time. So maybe they go out and come back in, that gets included. So that's a little tidbit in the statute that I thought was neat to learn. So once the timing out comes, this is a little snippet from our bench book. But so once a misdemeanor times out, they dismiss it. The only recourse that the state has then is they have to do the civil commitment process. So that's all this says. Those cases like Blunson and Reneke, those are all in our bench book as well. Then we have likely to time out. So we get to, it's a misdemeanor and it's early in the case. Like, this person's not competent and they're likely gonna time out. That's kind of where we see a lot of our cases. And that's when we need to get creative and really explore what they were talking about in the last session. What else are we doing to divert in the beginning? So are we coming up with different plans, using our 1622, using our PR, our mental health personal bonds? We have a program called Eliminate the Wait. And I know Elise isn't here anymore, but she hates the title of it. She's like, you're not eliminating the wait. But it's a little catchy, Eliminate the Wait. And it was developed by the Judicial Commission on Mental Health along with HHSC. And it's a checklist for each group who kind of, the stakeholders at the center of mental health and the criminal justice system. So there's a checklist for defense attorneys. There's a checklist for judges, checklist for the jailers. I'm like, who are those guys? The jailers. And they kind of really go through creative ideas that have been learned throughout communities, and then also statutorily what is required. So like for the jailers one, those things that Tim had up earlier where it was the, you have to do a comprehensive look at their medical background to make sure that they're getting the right medications, like they have to be provided medications, all those things that the jail kind of must follow, those are all in their checklist. So it's important to have our checklist because it gives creative ideas that you might be able to work out with your LMHA and then get your prosecutor to accept. But looking at the other checklists, you can get on them of, you're not upholding your part of the law here. You're not doing what you're supposed to be doing. And so it's a helpful guide. We went to Fort Bend County and they apparently used it, and along with the jail in-reach group, they don't have any people on their wait list anymore, which I just thought was impressive. For the whole county, no wait list. So it's just kind of, it's some statutory ideas, some creative ideas, but I know you're probably sick of hearing this, but like you really have to be creative because that law where you get on the train and you never come off the train, that's where we're all headed. I provided this list. This I took from a different presentation, but I always feel like it's really helpful. Kind of what are my just general options if someone's out in the community, someone is incompetent and unrestorable. So you've been over these things today, but I think it's a good resource to have. And then you can kind of circle back to these court-ordered mental health services if you are doing the civil commitment route. We talked about this a lot already, so I'm going to skip over that, but that when someone is not restorable but not civilly committable, thank you, it's tricky. And you've heard about this already, but I'll go ahead and touch on it. So if you have a defendant who was previously found not likely to be restored in the foreseeable future, or they went to restoration services and never got restored, that presumption and that burden change. So for a new case, your defendant is presumed incompetent, and the state has to prove it. They said that already, but that burden switches from preponderance, which was your burden, to beyond a reasonable doubt. And the law states the court may not commit defendant unless there is a finding that they are likely to be restored in the foreseeable future. So if they've already been through it, they are adjudicated incompetent, they never have regained their competency, they cannot go back to the state hospital if they're not going to be likely restored in the foreseeable future, right? So I guess that's another thing to hold against the state. But so they have that burden, that whole thing shifts, but also you're prohibited from taking other actions. The code is cumbersome, but if you dig in there, there's a few nuggets. These are the three things I was really hoping that you guys would take back to your communities. Competency restoration services are not the same as mental health services. And that sending misdemeanants to competency restoration is perpetuating that problem, not only the waitlist problem, but also just that revolving door of the justice system and how your high utilizers just keep coming back if you don't do anything to stop the process. If you don't do anything different, they're going to keep coming back. And there are some options through the civil system when your client is unlikely to restore to competency or they have not succeeded. I know the first judge talked about AOT court, which is kind of in the same option of the civil system. It is up and coming. We have a lot of really great resources on what to do. Pretty much what it is it uses the black robe effect to make the client get some treatment. And it's only for outpatient services, but you can pull someone from jail who could be on bond. They can either dismiss the case or not and bring them in front of that judge with probate jurisdiction. And it becomes more of a community event. And the judge is holding the local mental health authority and the client to make sure that things are working out. So there is more oversight if you have maybe a judge who doesn't want you to just let someone go free, or even just let someone go free and go to the LMHA, that allows that judge to have oversight of what is happening, checking in with this client, and kind of using the threat of not jail, but involuntary commitment to kind of keep them motivated to stay on their medicine and work with the LMHA. So AOT courts are kind of another option that are really big and up and coming. Resources. So this is that Eliminate the Wait toolkit that I spoke about. This is on our website. It says October 21, but it has been updated since then. This is the bench book, which I have some copies of over here. And then this Texas Competency Restoration Guide is actually a good guide. I didn't mean to say actually. It is a good guide from HHSC about competency restoration. So it hits on kind of different things that I don't necessarily think about. So I feel like it's a good place to reference. And in that is that email address that Marissa was talking about, where you can email the forensic director directly and get help, maybe get somebody moved around. It takes a community, but get someone advanced through the list. This is not my chart. This is from HHSC. They recently did a roundtable with a bunch of different groups to try to figure out if there was a way to do a decision tree of where you should send somebody. So outpatient, jail-based, and they really tried to limit who goes to inpatient, so who goes to the state hospital, and kind of what things you need to be looking at. Because, I mean, the code really does just default to the state hospital. So knowing that these other options exist, and maybe something from HHSC with these criminogenic risks and the clinical activity, those might be good motivators to get somebody put on outpatient instead of inpatient. Good things you can tell the judge, arguments to be made. So always something to think about. Then we have our yearly summit. So other than writing the bench book, this is my baby. Make the summit every year. We try to really curate what topics are there, what presenters are there, and what is up and coming in the law and what things are working. So not only is it a great conference, but you get all of our free resources, and there's lots of time for networking, meeting with each other. Brush elbows with the forensic director, right? Know Dr. Torres by name and say hey, you remember me? We met at the summit. Can you help me with this case? Those are really valuable relationships, and you'll get to have those because the stakeholders that attend are judges and attorneys, but also we got the whole HHC crew. We got almost every LMHA attends. It's a good place to go. We do have limited capacity this year. It is offered online, but you don't get to brush elbows if it's online. So I have a few minutes left for questions. This is my email address if you need anything. Please don't hesitate to email us. If we don't know the answer, we'll find someone who does, and we'll connect you to them. I think that's it. Are there any questions? I know that is a lot of information in a very short time.